Okay, this is cause number 4060022511 MF180. On the Zoom, who do we have?
Kurt Laker, Your Honor, for the plaintiff, Rocket Mortgage.
And then present in court, I'm sorry, sir. She told me you were hard of hearing. I need to speak up. Can you hear me okay, sir?
Yes.
Okay. Let me know, is that thing working better?
Yeah.
Okay, thank you. So this is Rocket Mortgage versus Joseph A. Novak, Maria G. Novak, in the state of Indiana through its Department of Revenue. We're here for a mortgage foreclosure. There's been some things filed and we set this for hearing to try to sort things out. And sir, you filed some things contesting jurisdiction and service. Is that correct?
Yes.
Okay. What would you like to argue to the court?
Capacity. I don't know. Trial Rule 17A, the plaintiff must identify the real parties and interests.
And you feel they have not, done that?
Yes.
Okay. What else would you like to argue to the court?
Jurisdiction, which I guess is part of capacity, I guess.
Okay. And you're saying the court does not have jurisdiction? And why are you saying that?
Well, I'm asking what capacity. I don't know. I mean, like an officer, police officer, in their capacity as officer, then they can be in their capacity as their private capacity. I'm here in special appearance.
Before we jump into today's courtroom chaos, buckle up because this video features not one, but two sovereign citizens attempting to use some of the most bizarre legal theories you'll ever hear. In the first case, a mortgage foreclosure hearing quickly turns into a debate about jurisdiction, residency, legal definitions, and even a land patent dating back to the 1800s. The defendant believes that by questioning the meaning of words like resident, person, and property, he can somehow stop a foreclosure action from moving forward. But as you'll soon see, the court is far more interested in facts, service of process, and signed legal agreements than philosophical debates about language. Then, in our second case, things get even stranger. A man facing criminal charges attempts to separate himself from the defendant named in the case, claims to be appearing on behalf of that defendant, and introduces documents that leave everyone in the courtroom scratching their heads. The judge remains remarkably patient while trying to determine one simple thing: who exactly is standing in front of him. As the hearing unfolds, questions about competency, legal representation, and basic courtroom procedure begin taking center stage. What makes both of these cases so fascinating is the contrast between complex legal-sounding arguments and the simple legal realities the courts are focused on. Will either of these strategies work? Will the judges entertain these theories? And how long can patience last before reality catches up with courtroom fantasy? Stay tuned because the answers are every bit as unbelievable as the arguments themselves.
I understand. And that's how you filed your paperwork. Because I think you filed a motion to stay these proceedings pending a clarification of jurisdiction. It was one of the papers that you filed.
Yes.
And so we set this for hearing so we can get some clarification of what you're asking this court to do. And that's what I'm trying to figure out. I want to know what the plaintiff is asking and then what you are asking. Then I can see what kind of a relief I can grant or not grant. So you wanted to stay these proceedings pending clarification of jurisdiction. Is that correct?
Yes.
Okay. And why do you think the court does not have jurisdiction?
Well, I want capacity defined. What capacity am I being compelled here in?
All right. Anything else that you want to argue to the court?
Nothing I can think of right now. I'm drawing a blank. I'm
That's
good at writing this stuff up. I just
It's tough when you're under pressure here. I understand. So what I'm going to do is I'm going to hear from the plaintiff, and then I'm going to come back and hear from you in response to them, okay? From the plaintiff standpoint, Mr. Novak is contesting jurisdiction, saying that we don't have jurisdiction over him or this case. Any response from the plaintiff?
Yes, Your Honor. As the court knows, jurisdiction is acquired by service of summons. The plaintiff did deliver, or caused to be delivered, a summons to Mr. Novak by sheriff service. A copy of the summons and complaint was dropped off at his residence. Same residence that he used that as a return address when he filed his responsive pleadings with the court. So I don't think there's any dispute that that's where Mr. Novak lives. The complaint and summons were dropped off by the sheriff and subsequently mailed. Both of those facts are reflected on the court's docket. That is the means under Trial Rule 4.1A3 by which we establish service and effectively bring Mr. Novak into court. We believe we've done that. And at this point, all we're asking the court to do is review the service, conclude that personal jurisdiction exists over Mr. Novak, and order him to file an answer, a responsive pleading, or take whatever action he decides to take in response to the complaint.
Mr. Novak, I'm looking at the file, and I'm seeing a summons that was mailed and left at 7334 North 200 East in LaPorte, Indiana, which is the property that's subject to this petition for foreclosure. And under the trial rules, that's what they're required to do to obtain notice and jurisdiction.
Right away, we're seeing one of the most common sovereign citizen tactics, turning a straightforward procedural hearing into a debate about definitions and jurisdiction. Notice how the judge repeatedly asks simple questions about what relief is actually being requested, while the defendant continues circling back to concepts like capacity and special appearance. The challenge with this strategy is that courts operate on established statutes, procedural rules, and case law, not personal interpretations of legal terminology. The judge isn't trying to debate philosophy. She's trying to determine whether the court has authority over the case and whether proper service occurred. What's interesting is that the defendant openly admits he's more comfortable writing these arguments than explaining them under questioning. That often becomes a major problem because legal theories that sound persuasive on paper tend to fall apart when a judge starts asking direct follow-up questions. Watch closely because the plaintiff's response is about to bring the discussion back to the actual legal requirements that matter.
What other clarification are you seeking?
Residence. Well, he says, I'm a resident. Well, what makes me a resident? I don't know all these. When I look up definitions of things, and like like for instance, traffic, Trial 9. I mean, you look up, there's definitions of words, and you go to another title, and there's a bunch of other definitions. The definition keeps changing. My view of the word residence, it's Latin. Res is the object of a trust. Ident is the same as identical, identify. Resident, to me, I think that means you're saying you're the object of a trust. And I know all these words have legal terminology. I don't know what they, maybe my definition of that is wrong.